As was told by me in the past, in this part 28, as far as our lecture series is concerned, we start discussing criminal procedure code in the real sense of the term. Now, during the course of introduction, we have learnt as to what is the distinction between substantive law and the criminal law, namely the criminal procedure code with which we are dealing. So imagine a situation where the offence of murder has taken place as defined by section 300 of the Indian Penal Code. What is the procedure that is required to be followed in order to convict a person who has done an act which amounts to an offence is nowhere mentioned as far as Indian Penal Code is concerned, and hence we start dealing with the provisions of the Criminal Procedure Code. So now this is a time. What is the manner in which anybody can set criminal law into motion, for which we start discussing right from section 154 up to section 176 of the Criminal Procedure Code. This chapter deals with information to the police and their power to investigate. And then, if this has got reference to fourth vertical column of the first schedule of the Criminal Procedure Code, with which we had discussion at the time when we learned the importance of the first schedule of the Criminal Procedure Code, taking into consideration 6 vertical columns of the first schedule of the Criminal Procedure Code. So now this is at present, this is the offence of murder which has taken place, but which has taken place in presence of somebody. What you expect him to do? Such a person by all means can set criminal law into motion. How? By following the procedure which is laid down as far as subclause 1 of section 154 of the Criminal Procedure Code is concerned. Namely, such a person who knows commission of the offence of murder will go to the police station. He will meet the officer in charge of a police station. He will start telling the information which he knows regarding an offence, which will be reduced into writing by the officer in charge of the police station or under his supervision, which is required to be read over to him, and at the end such a person who has given the information which is reduced into writing, which is signed by him, has to sign the same, and this is the first information which is first in point of time, hence we call it first information. And as it is reduced into writing and you have a report thereby, this is what is known as FIR, namely the first information report. This is the manner in which he has set law into motion. Now it is the responsibility of the government to maintain law, peace and order in the society, and these are the powers which are delegated to the police department. Hence, the police officer will start with the investigation, and by investigation we mean collection of evidence in order to prove the guilt of the accused person beyond reasonable doubt in a court of law accordingly, which is dealt as far as the rest of the part of this chapter is concerned. But then mind well one thing at this point of time only, if the nature of the offence is non-cognizable, this is murder is a cognizable offence, and because of the fact that the nature of the offence is cognizable, which reveals commission of a cognizable offence as made very clear, with which we shall be dealing as far as subclause 1 of section 154 is concerned, what happens if the nature of the offence is non-cognizable and the person goes to the police station for the purpose of setting criminal law into motion? Naturally, the officer in charge of the police station is bound to tell him, as the nature of the offence is non-cognizable as per 4th vertical column of the first schedule of the Criminal Procedure Code, I have neither right whereas not to start with the investigation. And such a person is directed, referred to magistrate as far as subclause 1 of section 155 is concerned, where he has to go to the court of magistrate and lodge what is known as complaint from the point of view of setting criminal law into motion. During course of our lecture, who can set criminal law into motion? What is the procedure as far as taking cognizance of an offence is concerned, with which we shall be dealing right from section 190 up to 199 of the Criminal Procedure Code. But as we confine ourselves to right from section 154 up to section 176 for the time being, the person, anybody can set criminal law into motion if the nature of the offence is cognizable by following the procedure which is laid down as far as subclause 1 of section 154 of the Criminal Procedure Code is concerned. Who has
set criminal law into motion is entitled to have a copy of first information report forthwith without any cost. Duty of the officer in charge of the police station to give him a copy free of cost forthwith, and the right of the person to get a copy of FIR. Who has set law into motion? That is as far as subclause 2 of section 154 is concerned. Whereas if you read section subclause 3 of section 154, when there is refusal on the part of the officer in charge of a police station to record the information which reveals the commission of a cognizable offence, such a person has to reduce into writing substance of the information, and that can be sent, that shall be sent by registered post acknowledgement due to the district superintendent of police or commissioner of the police, who himself may start with the investigation or depute his subordinate to start with the investigation, which is a process whereby evidence is collected. So this is subclause 3 of section 154 of the Criminal Procedure Code. Now, what is investigation? If you read section 2H, subclause H of the Criminal Procedure Code, investigation includes all proceedings under the code for the collection of evidence. In general, investigation is always carried out by the police, barring only one exception, which is laid down, with which we shall be dealing during course of time as far as section 202 of the Criminal Procedure Code is concerned, where there can be an investigation by a private person also. Otherwise, investigation is always by the police. Now, which empowers police officer to start with the investigation is made very clear, or which authorizes police officer to carry out investigation is made very clear as far as subclause 1 of section 156 is concerned. There may be FIR, there may not be FIR, but the police officer has got right to start with the investigation. He has got right to collect the evidence when he has got reason to believe that the nature of the offence that has taken place reveals commission of what is known as a cognizable offence. Naturally, which is the police officer who has got power to start with the collection of the evidence is the next question for our consideration. Now, jurisdiction of the officer or jurisdiction of the police officer or jurisdiction of the police station is nowhere mentioned in the Criminal Procedure Code right from section 1 up to section 484 of the Criminal Procedure Code. But the time, if you read subclause 1 of section 156, this is the time for you to have cross reference to. Now, that police officer has got jurisdiction within whose local jurisdiction the offence has taken place, and that is required to be correlated as far as jurisdiction of a criminal court is concerned. And hence, to understand jurisdiction of a criminal court, you have to start reading right from section 177 up to 189 of the Criminal Procedure Code, which deals with territorial or local jurisdiction of a criminal court. So, are you bound by law to set law into motion by going to the police station within whose local jurisdiction the offence had taken place? The answer is in the negative. You can lodge FIR with any police station,
But as far as the jurisdiction of the police station with respect to collection of the evidence is concerned, namely investigation is concerned, that is to be read as far that is to be understood by referring to right from section 177 up to 189 of the Criminal Procedure Code. And as far as Criminal Procedure Code is concerned, this deals with only one type of jurisdiction, namely what do you mean by total or territorial or local jurisdiction, with which we shall be dealing in detail during course of our lecture. Now, when there can be investigation with respect to a cognizable offence without any order from the court of law? Yes, as per subclause 1 of section 156. But what about if the nature of the offence is non-cognizable? And then if the nature of the offence is non-cognizable, in that case there can be investigation only when the order is given by the court of law, as far as subclause 2 of section 155 of the Criminal Procedure Code is concerned. So this is the manner. Details we will work out regarding both. For example, when we shall be dealing with FIR, what is FIR? The first information which is reduced into writing, which is first in point of time. So now this is as we deal with FIR, we shall be dealing with what is the evidentiary value of FIR. And in order to understand evidentiary value of FIR, we have to along with the Indian Penal Code, now we have to have reference to the provisions of the Indian Evidence Act. Namely, what is the evidentiary value of a first information report? And there we will come to know that, well, the information report is not a substantive piece of evidence. In other words, it is not proof of the fact stated therein. Then what is the importance of it from the point of Indian Evidence Act? The person who had set law into motion, namely the first informant, if he is called as a witness on behalf of the prosecution at the time of the trial, and when he is in the witness box, and when the oath is administered to him, and when he is subject to examination in chief, cross-examination, re-examination, the importance of the FIR is that it can be used for the purpose of corroboration as per section 157 of the Indian Evidence Act is concerned. It can be used as for the purpose of contradiction as far as section 145 of the Indian Evidence Act is concerned. It's not only two, these are the only two sections that come into play. No. Along with that, there are many more sections with which we shall be dealing during course of our lecture. For example, now in order to infer the conduct, FIR can be taken into consideration as far as that becomes relevant as far as section 8 of the Indian Evidence Act is concerned. Now, if the FIR or first information is given by an accused person, naturally confession made by an accused person cannot be is not admissible as a piece of evidence, because that is hit by section 25 of the Indian Evidence Act. But then section 27 is an exception to section 25, which says if the confession leads to a discovery of a material fact, then that is admissible as a piece of evidence, that becomes relevant, no doubt about it. So now you must have understood the importance that I had told you in the past. In order to understand Criminal Procedure Code, every now and then we will have to refer to the provisions of the Indian Penal Code, we will have to refer to the provisions of the Indian Evidence Act, and then only it will be possible for us to understand the provisions of the Criminal Procedure Code with which we are dealing. If accused person himself, if at all he is accused of an offence and is arrested by the police, and if he is ready and willing to confess to the police, naturally confession made to the police not admissible. And hence which confession is admissible? Law relating to confession is dealt by the substantive law relating to confession is dealt by the provisions of the Indian Evidence Act, right from section 24 onwards. Yes, but then as far as judicial confession is concerned, during course of our lecture when we will read section 164. There we will learn what is the manner in which a judicial confession is required to be recorded. And then it's not only one section 164, along with section 164, as far as keeping of the record is concerned, we will read section 281. And along with section 281, this is the time, what is the effect if the confession is not recorded as per section 164 to be read with section 281? What is the effect of such irregularity is dealt by section 463. There are some chapters in the Criminal Procedure Code with which it may not be possible for us to work out all the details. If it is possible, or if it is needed, or if it is required, or if there is demand, or there is any sort of requirement on your part, by all means we will work out details. But then this is the time when I had drawn your attention to section 463 of the Criminal Procedure Code for me to draw your attention to the chapter, namely right from section 460 up to section 466 of the Criminal Procedure Code. And the heading of the chapter is irregular proceedings. Section 460 enumerates 9 categories, and if this is an irregularity which falls under any one of the categories, that irregularity will not vitiate the proceeding. Whereas if you read section 461, that has enumerated 17 categories. And there it is made very clear, irregularities that will vitiate the proceedings. So this is as far as section 460 is concerned. Whenever you read section 460 and you have got a back reference, namely you are dealing with a particular section of which mention is made as far as any one of the categories which are laid down by section 460, time for you to have reference to it. Section 462 deals with a situation where a court has got no jurisdiction and court has dealt with a case beyond jurisdiction. What is the effect of it is made very clear. This again we shall be dealing when we will start. I will have reference to this section at the time of discussing right from section 177 up to 189 of the Criminal Procedure Code, dealing with what? Jurisdiction of a criminal court, which is made very clear as far as section 177 is concerned, which says every offence shall ordinarily be inquired into and tried by the court within whose local jurisdiction it was committed. And then we will take into consideration the exceptions to the same, to be read with section 462. Now I had drawn your attention to section 463 just now. Now section 464 deals with the cases where the charge is framed by the court of law, but there is error, there is a defect as far as framing of the charge is concerned. What is the effect of it is made very clear as far as section 464 is concerned. Now there is a clear-cut distinction between irregularity and illegality. Irregularities can be regularized, but illegalities cannot be legalized is the basic principle. And hence now, as may not be possible independently or in isolation to learn the importance of the chapter, namely irregular proceedings, right from section 460 up to section 466. But the time for me to remind you that as you are supposed to do homework as far as the second schedule of the Criminal Procedure Code, which deals with various forms, right from form number 1 up to form number 56, the importance of the first schedule of the Criminal Procedure Code. Similarly, this is the chapter to which you have that we will learn when we will start discussing right from section as far as section 164 is concerned. Now, investigation. What do you expect of officer in charge of a police station to do? And the first and the foremost step that is required to be done on his part when he starts with the before he starts with the investigation, to send a report to the magistrate as far as section 157 is concerned. There are some details which are required to be worked out, with which we shall be dealing as far as the steps that are required to be taken by the officer in charge of a police station. But then this is first step, that is, what he will do, he will have to submit a report to the magistrate. And what do you expect magistrate to do? Magistrate may conduct an inquiry or may not, and give a direction to carry out investigation as far as section 159 of the same chapter is concerned. So this is the manner where investigation starts. And what is investigation? This is a process whereby evidence is collected. And what is the manner of the evidence that is required to be collected? It will entirely depend upon the nature of the offence. So all steps are taken by the police officer. He will go to the spot. He will carry out what is known, if it is a case of a murder, he will carry out panchanama of a dead body. What is panchanama? Reducing into writing factual situation in presence of two independent respectable inhabitants from that particular locality which is required to be proved. He will have to find out cause of death, and hence in order to find out cause of death, if it is not possible, the matter is referred to the executive magistrate as far as section 174 of the Criminal Procedure Code is concerned. And then magistrate will give a report as to what is the cause of death. So cause of death may be culpable homicide, it may be culpable homicide amounting to murder, it may be culpable homicide not amounting to murder, it may be death or death by rash or negligent act as dealt by section 304A of the Indian Penal Code, it may be dowry death as dealt by section 304B of the Indian Penal Code, it may be an accidental death, it may be a case of a suicide, or it may be a natural death also. So the matter is referred to the executive magistrate accordingly. Now the police, what they have to do, once they have identified the dead body, this is the time for them to start with the investigation, namely collection of the evidence. And for the purpose of collection of the evidence, police officer has got power to call anybody who is associated or who has got knowledge regarding commission of offence for the purpose of his recording his statement to the police station. And what he will do? Such a person, if he is called to the he can be called to the police station, but no person who is under 15 years of age or any woman, as far as section 160, if you read the proviso which makes it very clear, shall be called to the police station for the purpose of recording statement as far as the collection of the evidence is concerned. And then the two sections to which we will refer to is section 161 and section 162. Police officer has got power, police officer has got right to carry out search, and the search can be carried out in the absence of search warrant by following the procedure which is laid down as far as section 165 of this chapter is concerned. There should not be any inducement or threat at the time of the collection of the evidence is made very clear as far as section 163 is concerned. Now imagine a situation where police have arrested the suspected person or who is accused of the commission of the offence. During the course when we dealt with the provisions as far as arrest of persons is concerned, right from section 41 up to section 60, there we have learned a person who is arrested is required to be produced before a magistrate within a period of 24 hours excluding the period of journey. So he is arrested by the police. And now they want him at the police station for the purpose of interrogation, for the purpose of getting information. What is expected to be done on the part of the police officer? And police officer has to follow procedure which is laid down as far as section 167 of this chapter is concerned. The maximum number of days for which a person can be granted police custody, where he shall be in the police lockup, he shall be in the police custody, he shall be at the police station only, is 15 days, and that shall never exceed 15 days under any circumstances when you start reading section 167. But then what happens? Is it that he will get a police officer or investigating officer will get a police custody for a period of 15 days at a stretch? No, that will depend upon the discretion of the magistrate. And for that, if the magistrate thinks that it is necessary for the purpose of collection of the evidence, he may or he may not. And then After expiry of the period of 15 days or before that also, magistrate has got power to grant what is known as magisterial custody or judicial custody. So he shall be under the control of magistrate accordingly. So this is police custody and magisterial or judicial custody as dealt by section 167. If 3 days police custody is granted and the investigation is not complete, then the next section that comes into operation is section 170. After this period, within a period of 3 days, then such a person is again required to be produced before the magistrate with a request to grant a police custody. So section 170 comes into operation. And then when the collection of the evidence is over, the police, their case is ready, the police will submit a report as per subclause 2 of section 173 of the Criminal Procedure Code. Investigation result into submission of such report as far as subclause 2 of section 173 is concerned, and because of the fact that this is a last report, this is what is known as final report, which is also known as challan or charge sheet in day-to-day life. We don't come across this term anywhere in the Criminal Procedure Code. But what do you mean by charge sheet? The report which is submitted by following the procedure which is laid down as far as subclause 2 of section 173 of the Criminal Procedure Code is concerned. With this now, there may be a situation where the person is arrested on the accusation of an offence, but the investigation reveals that there is no evidence against such a person. Then section 169 of the Criminal Procedure Code will come into operation. Such a person is set free. But mind well one thing, once a person is arrested, unless there is an order on the part of the magistrate, and unless such a person, he can be set free subject to certain conditions which are required to be fulfilled, and this is exactly dealt by what? Depending upon the nature of the offence, whether it is bailable or non-bailable, and hence this is taken care of right from section 436 up to section 450 of the Criminal Procedure Code, which deals with provision regarding bail and bonds, with which we shall be dealing, no doubt about it. But these are the steps. So investigation results into submission of report as per the provision. Now, if a death of the person has taken place when he was in the police custody, naturally section 176, which is a mandatory provision that comes, executive magistrate shall conduct an inquiry to find out cause of death. So this is as far as section 176 is concerned. So as we proceed further, right from section 154 onwards, we come to know the steps that are required to be taken by the police for the purpose of what? For the purpose of for the purpose of collection of the evidence. Now, when we were referring to section 154, somebody goes to the police station and sets law into motion. As police officer has followed officer in charge of the police station has followed the procedure which is laid down as far as subclause 1 of section 154 is concerned, immediately he will register or is maintained at the police station. And then what the police officer in charge, substance of the information is required to be reduced into writing into this particular diary, which is known as police station diary. This is also known as general diary. So I will reduce into writing substance into the same. If it is a non-cognizable, this is for cognizable offences. If somebody goes to the police station and wants to set law into motion, but if the nature of the offence is non-cognizable, police officer will reduce into writing in a diary in a police register meant for the purpose of recording of the information which reveals commission of a non-cognizable offence, and then refer the person to the magistrate for the purpose of setting criminal law into motion by lodging a complaint. So what is complaint? Complaint is an allegation which is made orally or in writing to the court of magistrate with a view that he should take action that some person, whether known or unknown, has committed an offence. As defined by section 2D, complaint is never to the police station. It is always information which is to the police station, whereas complaint is always to the magistrate. And then whenever such a person is accused person is produced before the magistrate with an application with a request to grant a police custody, this application is always accompanied by a copy of the case diary. Case diary doesn't form part of the charge sheet. By charge sheet I mean the final report, as it is used by everywhere, as far as though it is nowhere used in dealt by the provisions of the criminal procedure code. So it never. But then the importance of this case diary. So there can be a general diary, or there can be case diary. And what is case diary? As soon as the investigating officer starts with the investigation, he will reduce into writing every step that is taken by him for the purpose of collection of the evidence, and this has got reference to during course of time. I shall try to explain importance of section 172 of the same chapter. Now, in this manner, you will realize that it may not be possible for you to read one section and understand the same. First of all, it is necessary for you to correlate the sections, and once you start correlating the sections, it becomes very easy for you to understand the topic with which we are dealing. So now this has got, again I repeat, this has got reference to the provisions of the Indian Evidence Act 2. Now where at the time of discussing section 154 and what is its evidentiary value, there we learned that confession to the police is not admissible. Yes, do correct. But imagine a situation where confession is made by the person who went to the police station and he died in the police station itself. Now in that case, for example, that can be, or he died afterwards, then section 32 subclause 1 of the Indian Evidence Act will come into operation, which deals with dying declaration. In other words, evidence of that person becomes relevant who cannot be called to the police station. For example, the person who was attacked went to the police station. He went to the police station and he gave information to the officer in charge of the police station and died there by following the procedure which is later on as far as subclause 1 of section 154 is concerned. Correct? Now we say first information report is not admissible, is not a substantive evidence. But here it is, section 32 is an exception. Confession is not admissible by an accused person. But if it is an admission and not, if it is non-confessional statement, that becomes admissible as far as section 21 of the Indian Evidence Act is concerned. At times, for example, in order to know where the person was at the time when the offence had taken place, then section 11, when we talk about defense of alibi, that comes into operation, with which we shall be dealing. So, to understand the procedure with which you have started dealing now, this is the time for me to again remind you that it is necessary for us to refer to many of the provisions as far as the Indian Penal Code is concerned, or Indian Evidence Act is concerned, or the time for me to draw your attention when we shall be dealing with section 164, which deals with judicial confession. What is the practice that is required to be followed as far as the judicial magistrate at the time of recording of the confession is concerned is made very clear by the directions which are given as far as criminal court manual is concerned. It is made very clear by the higher judiciary, namely the High Court, to the lower judiciary, that when you talk about, you start implementing the law, I mean, try to understand the meaning of the law, not in its word, but in its spirit. What is the purpose behind it? That it has to be taken into consideration, and hence the importance. As we proceed, as I told you, right from section 154 up to section 176 of the Criminal Procedure Code, there are some details which are required to be mentioned, required to be worked out, with which we shall be dealing during course of time, no doubt about it. But this is the time where we start with the provisions. We start with the provisions for the purpose of what? For the purpose of understanding as to what is the manner in which one can set criminal law into motion, and that we have learned. The one can set criminal law into motion by following the procedure depending upon the nature of the offense, whether it is FIR or whether it is a complaint. That is point number one. And during course of time, when we will start right from section 190 up to 199 of the Criminal Procedure Code, we will try to understand as to when cognizance of an offense shall be taken by the court of law in detail, and rest of the provisions with which we will continue our discussion as far as next part of our lecture series is concerned.